there isn't a single independent person who's come out with independently verifiable evidence to suggest that there is any kind of systemic jury intimidation in this country, or a problem that can't be avoided by moving a trial from one geographical location to another. And let me just say very quickly that in a letter, in an answer to a written question from the Fine Gael Justice spokesperson in the Dáil, Charlie Flanagan, Dermot Ahern had to concede that there aren't even separate statistics kept for intimidation of witnesses as distinct from juries. And the obvious reason for that is there are no instances of intimidation of juries that are serious enough to keep statistics about.
OK, Senator Eugene Regan, you're also a lawyer as well, but you're the Fine Gael spokesperson and justice in the Seanad. Michael Finucane saying no evidence to suggest juries have been intimidated. I disagree with his analysis,
and I think it's the wrong starting point. The fact is, the legislation which has been put forward by Dermot Ahern here is to make the directing of a criminal gang an offence, and being a member of a criminal gang an offence. Now that's the starting point. We know we have a problem with gangland crime. That's the fundamental problem which has been addressed in this legislation. Now, in relation to the use of the special criminal courts, that has been tried and tested and has worked. And it's also been upheld to being appropriate in certain cases. Given the continuous carnage on our streets, the killings, gangland killings, the lack of convictions, I believe that the criminalising these offences and using the special criminal courts is appropriate. Now,
what do you make about that letter that was written to the Irish Times, signed by some 113 or so lawyers who came out very strongly against the bill?
Well, what I would say is this. There are a lot of people exempted from serving as on a jury. And none of those people, the lawyers who signed that, are entitled or ever did serve on a jury. The fact is, if you're living in Limerick, would you want to serve on a jury? On a gangland crime issue. I don't think you would. Now, you can talk about moving juries around, etc., but I think there's the hard reality of the difficulties that exist and the perniciousness of this crisis with gangland crime, that I think that the use of the Special Criminal Court is appropriate. I appreciate the DPP has the authority, and the principle is established that they can be used in certain cases. And I think what has been done here is to ensure that these particular offences can be the subject of the special.
I mean, it's interesting that Fergus Flood has referred to in his view, the idea that juries could be intimidated. But of course, one of the big reasons why Dermot Ahern brought this bill in came after the murder of Roy Collins in Limerick just last April. We had his father, Steve Collins, on the show last week, speaking very movingly about the level of intimidation he's come under. Now, in that sense, you're talking about intimidation of witnesses. We're not really clear at all whether this bill will give protection to witnesses other than the regular protection that's out there.
Can I McCarthy, yes, just to finish on that, the thing is, when a witness is intimidated, it's quite obvious, because he or she will withdraw their evidence or refuse to speak up to the evidence that they But where a juror is intimidated, how actually is that to be known? It's very difficult to know when that's has happened, and therefore, Judge Fergus Flood, when he says the wrong, I think Michael is misquoting him. He is saying that what he is saying is that on the evidence that he saw, he felt the judgment and the finding was wrong, and he may have come to a different decision. And that somebody may have been influenced. But I think that is the point. It is next to impossible to know, and it's only somebody who's very, very close to the action can know that there's juror intimidation.
I know, Mike,
could I just say something in response to that particular point, and Eugene may not be aware of it, but there are many, many instances where jurors have spoken up directly to trial judges or approached the prosecution or approached the Gardaí to indicate that something has gone wrong or that something has happened that is inappropriate. Jurors have no problem making it clear that the process is being interfered with on the rare occasions that it has happened.
There is evidence that jurors have been intimidated then, or have been subject to some form of intimidation. That's what you're saying.
No. I'm saying that on some occasions things have happened that to indicate an interference in the process, not intimidation, but say where somebody is approached by a member of the public and an inappropriate conversation takes place. There was also an incident involving an inappropriate level of contact between jurors and Gardaí a couple of years ago that led to the setting aside of a conviction. But nobody wants to talk about that incident.
I know you want to...
Well, I suppose first of all, I mean, I'm here with two lawyers, a solicitor and a barrister, right? So I'm not, okay? I'm coming at this. I'm a citizen, right? I'm somebody sitting here observing this and reading the reports in the media and trying to understand what effect this will have. And I suppose for me, I mean, you talked about Stephen Collins speaking on your programme last week, and I heard it, and it is very moving. But there isn't one thing in this bill that would have changed the outcome for them, because this is not going to protect witnesses. You still have to have witnesses in the Special Criminal Court. Or do we now not need witnesses to give evidence at all? Is it just going to be Garda opinion? Because that's really what that's about. So there's a good piece, well, for me, I think there's a good piece in the Tribune today, right? And two corresponding opinion pieces, one in favour of the bill and one against it. But Michael Clifford's piece, which is against the bill, basically calls it the Something Has to Be Done bill. And to a large extent, there's bits of it that are the Something Has to Be Done bill. Because if the DPP can already refer cases to the Special Criminal Court, why do we need additional legislation? So nobody is explaining that to me, because that doesn't make... So if we can already do it, that's the first thing. And the second piece is... even I can understand that the introduction of a hearing where a person can be detained for another number of days in absentia, like without their solicitor or their lawyer or them being in front of a judge. Like, if we heard that going on in the States, in Guantanamo, we would think it was appalling. I mean, just because somebody is suspected of something doesn't, when did we start saying, like, it's now got to that stage, right, where if the guards arrest you for being a member of a criminal gang, but you've lost all rights. Just the suspicion of your membership of something that's considered so heinous is now, taking away all your rights. You could be a guy, right, who's suspected of a membership of a criminal gang, and you have less rights than a guy who is accused of murdering and raping 3 women.
Okay, Eugene.
How is that fair?
You see, this has been... the arguments we're hearing now are typical of what has emerged over the last week or so, because it's only been over the last week or so, really, that we've had any sort of level of energetic analysis of this particular bill. What do you say to Sive McCarthy's concern that this is eroding, as Michael Finucane says as well, it's eroding basic civil liberties, and then weigh that up with the likes of the Collins family down in Limerick, who are under enormous pressure from the lives they have to lead there and the kind of gangland crime that we have going on? I mean, where is the solution? What is the solution?
Well, first of all, Siv's point that this would not have changed anything down in Limerick. It would have changed everything. Because we can talk about the special criminal courts, we can talk about the safeguards that are in the bill, etc. But the point is, you are criminalising anyone directing or being a member or aiding or abetting a criminal gang. That's the essence of this bill, and that is what has been lost sight of here. Now, in terms of the balance, because it is a question of balance, the legislator is entitled to interfere with civil liberties, with liberty of a person. But it has to be done in a way which is, first of all, it has to be necessary and it has to be proportionate. Given the problem we have with gangland crime, it's necessary. Given the provisions that are in the bill, we would have liked more time on those provisions to ensure that the safeguards were there so that it is proportionate. But I think, on balance, the bill is necessary and required in the extraordinary circumstances we have today.
Okay, but I mean, I suppose there's an issue of trust. Can we trust, this is going to be enacted, I mean, this will be brought into legislation. Can we trust the new system to ensure we do not have erosion of people's civil liberties, notwithstanding the fact that people who are living in these places also have their civil liberties eroded, but that we won't have miscarriages of justice in the future?
Well, there's no guarantee, but the point is the Special Criminal Court has been upheld as an appropriate vehicle in certain cases, other than for subversive type activities. And this gangland crime area is one which I think is fitting for the Special Criminal Court.
Okay, Michael Finucane.
The sending of a case to the Special Criminal Court is at the moment in circumstances where the DPP is satisfied, presumably on the basis of some type of evidence or information, that the ordinary courts are inadequate. This bill presumes that you will go to the Special Criminal Court unless some circumstances intervene to suggest otherwise. And to talk about safeguards in the bill, there aren't any.